It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. I've been raking up off these niggas for a minute now. Hey, y'all gonna learn to listen one way or another though. Hey, let's get it. Let me show you how I keep the money coming. Strapped up like he check, nigga run it. In the mirror, yeah, I love what I'm becoming. Ain't no discussion, boy, don't make me spit your onion. Ayy, let me show you how I keep the money coming. Strapped up like he check, nigga run it. In the mirror, yeah, I love what I'm becoming. Ain't no discussion, boy, don't make me spit your onion. Ayy, flashback to the days I was in the days. I was sleeping on the couch, couldn't nobody stay. I was serving up the chicken, couldn't get a raise. Now I'm cooking up the game like I'm Bobby Flay. Fuck rap, I ain't got no friends in this shit. Put them M's to the front like a Benz in this shit. I be swimming through the money, got some fins in this shit. I be stomping through the street like some Timbs in this bitch. Made trends in this shit, but some IOUs, but I don't lose. Construction high, tighten them screws. Tie my shoes, back on the block, straight to the bag, ho. Jumping off the porch for that green like a tadpole. What's going on, beautiful people? It's the kid J Nolan here. Happy Friday. Hope everybody's doing well out there. Y'all know why we here, man. Y'all know why we're here. Okay, we all know that Drake has filed a lawsuit on UMG. You know what I'm saying? Federal. We also know before he went federal, he submitted a petition to the courts out there in Texas, basically trying to accuse UMG and iHeartRadio of doing some underhanded pay-for-play activities to amplify Not Like Us, to further besmirch his name in a public forum. We all know this. We've been talking about this for a minute now. But UMG, as of today, has struck back in official paperwork. Remember, when Drake's lawsuit hit the scene about a week or so ago, they issued a public statement in response to Drake. But this is their legal response to Drake as it pertains to the petition out there in Texas. And they are basically calling him nothing short of ridiculous and basically saying your booty hurt and now you want to try to play. You want to try to play dumb. You know what I'm saying? Pause if you need to, but that's what's going on. All right? We ain't going to waste too much time because, this is legal paperwork, so there's a bit to get through. So let's just go ahead and address it. Let's talk about it and move on with our lives, okay? All right. So here we have UMG's motion to dismiss Drake's petition filing in Texas. And their reasoning is under the Texas Citizens Participation Act, which they're going to get into. So let's just go ahead and make our way through this. Some of this stuff we're going to bounce around a bit because they repeat themselves a lot as it pertains to the TCPA. And y'all ain't really interested in all that shit, let's be honest. But here we go. Here's the introduction. Petitioner's Rule 202 petition arises out of an ongoing feud between two prominent rap artists, Petitioner stage name Drake and Kendrick Lamar Duckworth stage name Kendrick Lamar. UMG distributes the recordings of both of these artists. Beginning in the spring of 2024, Petitioner and Kendrick Lamar each released recordings containing lyrics which attacked the other performer, which are known within the genre as diss tracks. This rap battle culminated in a recording by Kendrick Lamar called Not Like Us, released in May 2024, to which Petitioner has taken offense. Rather than addressing his grievances with Kendrick Lamar, Petitioner has resorted to strategic legal retaliation against UMG and others in an apparent effort to pressure them to limit the distribution of Not Like Us. Okay? So this introduction here pretty much mirrors the sentiment that they had in their public statement, basically stating that we've worked with Drake for many years. Under our time working together, he's decided to enter into multiple rap battles in which he defamed other artists or used inflammatory language towards other artists in the music industry. And they've always backed him up in these exchanges, right? Now, all of a sudden, he takes an L. He's embarrassed and he wants to sue. He doesn't want to sue Kendrick Lamar, directly. So he wants to sue the company for taking part in a defamation scheme to embarrass him, make him look bad in the public, and also devalue his negotiating power in their pursuit of making another deal, right? So they say here he engaged in a rap battle, which consists of diss tracks, and Not Like Us came out and changed his world. You know what I'm saying? Rock that motherfucker most specifically. Okay? So they say the TCPA protects parties from this exact kind of legal retaliation by providing an expedited process to summarily dismiss legal actions, including petitions for pre-suit depositions brought under Texas Rule of Civil Procedure 202 that are designed and intended to intimidate and punish people for exercising their First Amendment rights. So they're saying that they're protected by the First Amendment, freedom of speech, and basically covering Kendrick as well as the person who made the song, saying he's also protected for freedom of speech, and they're protected under this for distributing it and putting it out there, right? Indeed, Petitioner's Rule 202 petition is particularly baseless because on January 15, 2025, Petitioner filed a lawsuit against UMG in New York, asserting the very pay-for-play claim that Petitioner ostensibly seeks to investigate here. Because Petitioner's Rule 202 petition is related to and was filed in response to UMG's protected free speech, and because Petitioner cannot carry his burden to establish by clear and specific evidence that he is entitled to pre-suit discovery under Rule 202, the court should dismiss Petitioner's retaliatory legal action against UMG and award UMG its legal fees. So they say they need to toss this shit out, and you need to pay us for wasting our motherfucking time. Looking at the clock, because you're cutting into your mother's fucking time. Just shout out to Loaded Lux. They didn't say that. Okay. So basically, they're saying you no longer need this pretrial discovery motion that you filed in Texas because you've already filed a federal lawsuit against us. So let's get this tossed out and we can really play. We can play the game that you really want to play. But let's get this little pussyfooting stuff out the way first, okay? Please and thank you. Simplest way to say it, right? Because he is alleging that they used pay-for-play schemes, such as paying iHeartRadio to amplify the song, such as paying influencers and taking away the copyright claims so that YouTubers and reactors could play the music and further promote the song. Of course, Drake is absolving himself of doing the same things while trying to implicate UMG. Just a quick refresher. We know this stuff though. So here in Arguments and Authorities, they say legal standard. The TCPA protects citizens from retaliatory lawsuits that seek to intimidate or silence them on matters of public concern through a special procedure for the expedited dismissal of such actions. Okay. First, the movement must demonstrate that the legal action it seeks to dismiss is based on or is in response to a party's exercise of the right of free speech, right to petition, or right of association. The burden then shifts to the non-movement to establish by clear and specific evidence a prima facie case for each essential element of the claim in question. Even if the non-movement meets this heavy burden, the legal action must still be dismissed if the movement establishes an affirmative defense or other grounds on which the moving party is entitled to judgment as a matter of law. In accordance with this framework, in moving for dismissal, UMG need only establish that Petitioner's Rule 202 petition was based on, related to, or made in response to UMG's exercise of one of the rights enumerated in the TCPA, such as free speech. Right? The stated purpose of the TCPA is to encourage and safeguard First Amendment rights by summarily disposing of lawsuits designed to chill those rights, not to dismiss meritorious lawsuits. Okay? The legislature commands that the TCPA must be construed liberally to effect this overriding purpose. Importantly, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss. And once again, what Drake was trying to do was get UMG and iHeartRadio to come to the table, show the books, show reference of any payments that will be out of the ordinary. He wanted to check their Zelle accounts and Cash Apps and other forms of exchange to see if there were any under the table payments processed to amplify Not Like Us. UMG is saying, sir, get the fuck out my office. Okay? They say a Rule 202 Petition is a legal action subject to dismissal under the TCPA. The TCPA permits a party to move to dismiss a legal action filed in response to a party's First Amendment rights. See, you see how they keep saying First Amendment? So this is very repetitive in nature. Therefore, we're not going to read through this whole thing because the entire motion to dismiss is based around the TCPA. And they're going to give you like multiple reasons as to why the TCPA applies to have this thing tossed. All right? So just giving y'all a heads up as I'm skipping through some of this. Now, one part that I found interesting when I read through this is that they say that they should throw it out because Drake is a public figure, a household name, or something to that effect. I found that to be pretty interesting as well. But we'll get there in a minute. They say the minority position is unpersuasive. So this is where they say how infrequent it is that Texas courts would not rule in favor of the TCPA. Again, I'm skipping through some of this because they make a lot of references to other cases that we're not privy to, that we don't have like enough context about to really try to break this down. And for saving time, we're just not going to do all that, right? So this is the part where they start getting into matters of public concern, right? Which is something that I was just kind of alluding to. So they say that his petition is in response to UMG's exercise of its right to free speech. Drake's petition is subject to dismissal under the TCPA because it was filed in response to UMG's exercise of free speech. According to the TCPA, exercise of the right to free speech means a communication made in connection with a matter of public concern. Okay? So here, a matter of public concern is a statement or activity regarding a public official, public figure, or other person who has drawn substantial public attention to the person's official acts, fame, notoriety, or celebrity. B, a matter of political, social, or other interest to the community. Or C, a subject of concern to the public. Because Drake's petition was filed in response to UMG's promotion and distribution of its sound recordings, First Amendment protected communication, and those recordings involve matters of public concern, this court should grant dismissal in accordance with the TCPA. Now, I wonder if a rap battle is necessarily identified as a matter of public concern, because of course the court of public opinion will determine who the rap battle winner is. I'm just asking a question. I can't say that to be certain though. UMG's promotion of its sound recording is communication protected, blah, blah, blah. But I just said that they made reference to the whole thing of him being a public figure. They say music as a form of expression and communication is afforded constitutional protection under the free speech clause. This protection extends beyond artists and performers, promoters, sponsors, and distributors of musical expression likewise enjoy First Amendment protection, even when done solely for business purposes, right? So this is where they intend to absolve themselves, okay? A person becomes a general purpose public figure only if he is a well-known celebrity. His name is a household word, which Drake is for sure. Petitioner enjoys household name status by his stage name Drake, as he is one of the most famous recording artists in the world, a fact acknowledged by in the petition, because he talked about how successful he was as an artist and how detrimental he felt that these rap lyrics were to him. Petitioner's unquestioned global celebrity and fame make him a public figure for purposes of the TCPA. Because Petitioner is a public figure and he alleges that the lyrics of Not Like Us are about him, UMG's communications were made in connection with a matter of public concern. Therefore, UMG's effort to promote the recording Not Like Us was an exercise of its freedom of speech under the TCPA. You see what I mean here? They just keep citing this thing. And of course, they're trying to make this extra compelling for the judge to go ahead and toss it because they don't want to deal with this shit. Plus, they got to deal with his ass in a whole nother situation. This is just a pretrial motion, pretrial discovery. Let's get to the federal shit, you know? That's what UMG is saying. And they probably going to request for that to get tossed out as well in the coming weeks. In this piece here, they say the fact that petitioner's Rule 202 petition is purportedly to investigate potential claims involving pay for play, as in payola. It does not sever the cause and effect relationship between UMG's protected speech and petitioner's legal actions. Again, even a tenuous or remote connection between the free speech activity and the retaliatory legal action would be sufficient to dismiss this action under the TCPA. Movements under the TCPA need only show that the legal action was filed in retaliation for the movement's free speech, not that the specific claims brought against the movement would have First Amendment defenses. Petitioner's petition was related to and in response to UMG's conduct in promoting music, the content of which petition dislikes. Therefore, the TCPA's protections are triggered. Petitioner's Rule 202 petition forms part of a wider multi-jurisdictional strategy to punish UMG for exercising its right to free speech. First, petitioner's counsel sent correspondence to UMG threatening to sue. Right? Remember, Drake was threatening. He wanted to see what they could do. And they said he was threatening to sue for defamation and harassment unless UMG agreed to mediate. Right? Now, wonder what type of mediation Drake was seeking, because UMG has been pretty responsive, other than the fact that they didn't care what he was talking about. Because they say, hey, we didn't make the record. We just put it out. So I don't know if they wanted to mediate with Kendrick, and UMG was like, shit, reach out to him yourself. But Drake ain't like that shit. They say petitioner then brought legal action against UMG in the state courts of New York, seeking pre-suit discovery, ostensibly to investigate similar baseless claims. Most recently, petitioner filed suit against UMG in the United States District Court of the Southern District of New York, bringing putative claims for defamation, harassment, and violations of New York deceptive trade practice statutes involving the same baseless payola claims. They on your ass. The Rule 202 petition before this court is just one front of petitioner's nationwide effort to harass and retaliate against UMG for exercising its free speech rights. Exactly the kind of litigation conduct that the TCPA is designed to protect against. Oh, man. They got this shit buttoned up. Furthermore, dismissal is warranted in this action because the TCPA's commercial speech exception does not apply. Under the commercial speech exception, the TCPA does not apply to a legal action brought against a person primarily engaged in the business of selling or leasing goods or services. If the statement or conduct arises out of the sale or lease of goods, services, or an insurance product, insurance services, or a commercial transaction in which the intended audience is an actual or potential buyer or customer. The defendant was primarily engaged in the business of selling or leasing goods. The defendant made the statement or engaged in the conduct of which the claim is based in the defendant's capacity as a seller or lesser of those goods or services. The statement or conduct at issue arose out of a commercial transaction involving the kinds of goods or services the defendant provides, and for the intended audience of the statement or conduct were actual or potential customers of the defendant for the kinds of goods or services the defendant provides. They say petitioner cannot establish that the commercial exception applies because UMG's First Amendment protected conduct does not arise out of a commercial transaction as contemplated by this TCPA. The Texas Supreme Court explained in Castleman that the commercial speech exemption applies only to certain communications related to a good, product, or service in the marketplace, communications made not as a protected exercise of free speech by an individual, but as commercial speech, which does no more than propose a commercial transaction. The exemption is not established unless the challenge statement was about the speaker's particular goods or services or the speaker's business of selling them. Here, there is no commercial speech at issue. Rather, only UMG's protected exercise of free speech is at the center of this controversy. UMG's distribution of sound recordings is core free speech, as established above. The fact that UMG derives profit from this activity does not transform its core free speech into commercial speech. Interesting. Furthermore, any of the lyrics on Not Like Us that petitioner might allege are defamatory are simply not about UMG's goods or services, nor do they propose a commercial transaction. Thus, in accordance with Castleman, UMG's core free speech activity that triggered petitioner to file his retaliatory Rule 202 petition is not commercial speech within the meaning of the TCPA. Here they're addressing the pre-suit discovery that he was requesting. He wants to investigate potential claims against UMG and iHeartMedia. Therefore, to survive dismissal under the TCPA, petitioner is required to establish by clear and specific evidence that the likely benefit of a deposition outweighs the burden or expense. Of course, he did want to depose them and have them questioned and have their files ran through. They say petitioner cannot carry his burden to establish entitlement to pre-suit discovery for at least 4 independent reasons. Number 1, petitioner did not file his petition in a proper court as required by Rule 202.2b. Petitioner has already filed suit on his potential claims, obviating any need for pre-suit discovery. 3, petitioner has offered no admissible evidence that would establish his entitlement to pre-suit discovery. That was something I was curious about as well. He didn't have any evidence. He just had hearsay. And they say, number 4, petitioner cannot show that the likely benefit of an oral deposition of UMG's corporate representative in Bexar County outweigh the burdens. Again, I'm still tripping on y'all Texans calling Bexar County Bear, but I don't live there, so more power to y'all. Okay. Now, in this not in proper court thing that they're talking about, they're basically stating that UMG doesn't have any offices in the state of Texas. iHeartRadio has offices in Texas. However, the lawsuit is primarily on UMG, and they're formed under the laws of Delaware. And again, they do not have an office in Bexar County nor anywhere in Texas. So they're saying that you filed this in the wrong court. Drake's petition seeks to depose corporate representatives from 2 entities, iHeartMedia and UMG. Petitioner filed his request in this court presumably because he believes that iHeartMedia's principal office is located in San Antonio, Texas, which is within Bexar County. But even if iHeartMedia resides in Bexar County, that does not make this a proper court in which to file a Rule 202 petition against UMG. Because UMG has no offices in Texas and therefore does not reside in any Texas county, there is no proper court in which a Rule 202 petition for pre-suit deposition to investigate potential claims may be filed against UMG pursuant to Rule 202.2b. But that fact is no reason to permit an improperly filed petition to proceed in this court. The Texas Supreme Court has expressly rejected the idea that Rule 202 may be used to drag witnesses from anywhere in the world into Texas for depositions merely because petitioner seeks information. Okay? The Rule 202 petition is a unique pre-suit discovery vehicle for use in the state of Texas. The rule does not guarantee access to information for every petitioner who claims to need it and does not make Texas the world's inspector general. Oh man, they being... These motherfuckers being sarcastic and everything. Simply put, petitioner will be unable to carry his burden to establish by clear and specific evidence a prima facie case of entitlement to pre-suit discovery because this petition was not filed in the proper court. Here they go into the fact that he's already filed a suit based on his potential claims, a federal lawsuit at that. So they say, why are we even bothering ourselves with this local joker shit? Okay, I'm paraphrasing in my own words. Furthermore, they state petitioner provides nothing. They said that shit with an accent on it. Outside of his verified petition, which alone cannot provide an evidentiary basis for a Rule 202 petition. Even looking into the petition, which would not satisfy petitioner's burden in any case, there is no evidentiary support for his asserted need for pre-suit deposition of UMG. Petitioner avers that according to one inside source known to petitioner, UMG made covert payments to a number of platforms, including radio stations, to play and promote Not Like Us, without disclosing those payments to listeners. And petitioner has learned of at least one UMG employee making payments to an independent radio promoter who had agreed to transfer those payments to certain radio stations and/or radio station employees. They say these claims from unnamed, unidentified, out-of-court declarants are classic hearsay and are not admissible as evidence. In addition to these inadmissible hearsay statements, petitioner cites to irrelevant past litigation involving UMG and other unrelated parties. These lawsuits do not provide any factual support for petitioner's alleged payola conspiracy between UMG and iHeartMedia and, of course, would be inadmissible as evidence under Texas Rule of Evidence 404b1. Petitioner has no admissible evidence to establish his prima facie case, and he will be unable to provide it. Therefore, dismissal pursuant the TCPA is warranted. Toss it out. Petitioner requests to depose both iHeart and UMG to investigate the relationship between them. But petitioner does not describe why a deposition of both iHeartMedia's corporate representative and of UMG's corporate representative would be necessary to investigate any alleged agreement between iHeartMedia and UMG respecting Not Like Us. Without such explanation, petitioner has failed to establish any likely benefit of a pre-suit deposition of UMG, let alone show that the benefits outweigh the burdens. And most of the burden is, they say it's going to be costly, time-consuming, and intrusive. They're calling it a blind deposition. Here, general denial. UMG generally denies every allegation contained in petitioner's Rule 202 petition and demands strict proof thereof in accordance with the applicable burden of proof. So they're saying, if you got any proof, bring it to the table, bitch. Because we ain't finna play with you. You have provided nothing. You just saying what you heard. You put a lawsuit on us based on what you heard, homie. So now they saying, this shit needs to be tossed out, and it needs to also charge him with our attorney fees and costs associated with defending against this legal action in the state of Texas for all of the inconvenience. And then they get into some exhibits that show Drake's lawsuit in New York, etc. We don't have to go through all that because we've already gone through that at length, talked about it multiple times. But basically, UMG is telling Drake, sit down, be humble. That's it. I'm going to tell y'all, though, man, as this thing continues, as that federal suit out in New York, continues to move forward and they're forced to submit further paperwork, probably submit their request for dismissal for that. And then Drake starts submitting more paperwork. I feel like some dirt is going to get revealed. UMG seems extremely confident in their position. And I wonder what else they're holding back. Because as you see, I said it before that they were going to throw in the fact that he's taking place in a rap battle. Because that's like the foundation of why these records were even made. So then you have to get into what a rap battle is, what constitutes a rap battle, the contents of a traditional rap battle. At some point, they were probably even harken back to his previous rap battles, quote lyrics that he said about other people, probably even quote the lyrics that he said against Kendrick Lamar. If this is the direction he really wants to go, some people say what he said would be of no consequence. He's the one that's suffering all of the financial loss. Okay. Well, as you can see in their request to dismiss this here, they said he took part in a rap battle, made diss tracks at each other, and now he wants to sue. So I think if you force UMG's hand, they're going to bring a fucking hammer. They're going to put the Thor down on your ass, sir. But hey, it's a free country. You can move forward if you like, as long as the judge is willing to participate. So we'll see how it goes. Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider, and I will catch y'all on the next one. Much love and respect, y'all. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef on computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but too raw, no gunner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.